This is Earl White, real estate attorney. This is a video about a risk of loss contract provision in real estate purchase and sale contracts. We're going to go over what is the risk of clause contract provision, what are the key elements involved in it, what type of scenarios would trigger this circumstance where risk of loss clause would come into play, and what are insights on the negotiations between the buyer and seller on the risk of loss clause. So first, what is a risk of loss clause? A risk of loss clause in real estate contracts is a provision in the purchase and sale contract that defines the responsibilities of the buyer and the seller when there is new damage to the property that was unanticipated. So the question is, when does this even come up? Risk of loss clauses come up in circumstances where you have a hurricane, like in Florida or other areas that have these weather events and flooding. You could have a situation where there's structural damage to a property, for example, like a building collapse that we had in Florida. You could have a fire where a building is destroyed, or any other major catastrophe that a building could suffer. So that's the type of things we're talking about when we're talking about why this clause exists. So there's a few elements that the parties need to negotiate with regard to risk of loss clauses. First issue to be aware of is that it is completely negotiable. So sometimes this clause doesn't even exist, and sometimes it's pro buyer, sometimes it's pro seller. This item, I think it's important to have in there, but it really doesn't come up much, and so sometimes it's not applicable to a specific transaction. The first point of negotiation tends to be, what is the percentage damage that would allow either buyer or seller to cancel? In other words, many times with these risk of loss clauses, we'll have language that says if there's material damage, perhaps defined as 5% of the purchase price or 10% of the purchase price, then the buyer has the right to cancel, or you could have it where both parties have the right to cancel. So what's that trigger point? What percentage is going to trigger this clause? Next, a key element is what the seller repairs obligation is going to be. You could have that the seller is just fully responsible for repairing any damages altogether, regardless how large, how small, but you could have that provision where the buyer steps up and says seller has to repair any new damages, and that's just going to be what the deal is. You can also negotiate the term of what's the seller's obligations to provide credits. Seller may prefer credits, and so that can be an element where the seller is going to take responsibility for credits. You could also have an option built into a risk of loss clause where the buyer can choose. The buyer can choose for the seller to repair the new damages. Buyer can choose for a credit from the seller for damages, or buyer can just choose to cancel the contract due to the change in circumstances. Another key element to drafting these clauses is what to do with insurance payments. If you have a fire, major event, presumably the seller has insurance coverage, and if they're going to get compensation for the event that caused the loss, then they could assign that compensation to the buyer, and then in theory the buyer is made whole, and that's a way, rather than the seller personally paying or the buyer taking on repairs or seller taking on repairs, let the insurance company pay for everything and the parties can move on without having to deal with the payments because of the insurance policy of the seller. Now, in terms of the insights on the negotiation, sellers and buyers will have different preferences. Some sellers would say, okay, look, I don't want to lose this buyer. I don't want to start the sale over again. How are we going to achieve this goal for the seller? The seller may say, okay, I'll conduct the repairs. The reason the seller may want to conduct the repairs is because they may be able to do it cheaper than the buyer. Perhaps they have contractors. Perhaps it can be more cost effective if the seller does the repairs, as opposed to giving a buyer credit. They'll just conduct the repairs themselves to save some money. Now, a seller may not wish to conduct repairs because it could be time consuming, it could be permitting involved, in which case they may say, look, we just want to get this to the closing table before there's any other problems. Just get this closing table, and they may want to give a credit to the buyer, and that just gets it closed faster. And so that's the seller's competing motivations here. Now, the buyer preferences for risk of loss. Now, this really is buyer specific as well. So a buyer may prefer the credit route, right? So we have the damage event. Buyer may prefer just to be given money from the seller rather than have the seller make repairs. And the reason this would be that the buyers can do their own contracting. They can pick their own people. they trust and don't have to rely on the seller's contractors, just because the sellers obviously are going to be motivated to do the least amount of quality work possible because they're just paying for someone else's property. So buyers would often prefer the credit. But on the other hand, some buyers might prefer to get the seller to conduct the repairs, because every time you do repairs on a project, there's the risk of substantial cost overruns. And so if there's going to be substantial cost overruns, the buyer would not want to be on the hook for those. So in that event, the buyer might prefer that the seller conduct the repairs and bear any risk for the overruns.